So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Because you just asked her the same thing. Because she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
Christina Berry. Good morning, Assistant Public Defender Lauren Attorney on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
An accused defendant demands answers from the judge, insists she should be free to walk out of court, and moments later another courtroom explodes into chaos over secret recordings, alleged witness tampering, and a judge who's clearly losing patience. What starts as confusion over a simple bond hearing quickly spirals into accusations of manipulation, courtroom misconduct, and a defendant whose own words may have just destroyed his case. But the biggest twist? The judge believes this wasn't a misunderstanding at all. It was a calculated move. Stay tuned, because this hearing goes from awkward to absolutely disastrous in a matter of minutes.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So in this matter, Ms. Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washington County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time
I served 30 days already.
and if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
All
right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So
Okay.
what do you want this set for, ma'am?
Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you've got to make a decision, ma'am.
If it got to go to trial, then it got to go to trial.
Okay. Do you want a jury trial or a non-jury trial?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury. Fine. That's fine with me.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by parody. The whole
That's-
McDonald's thing and then this and
This-
okay, let's try this one.
Before he makes more statements.
And I did record the-
That are false to this.
I
court,
recorded the call.
Criminalizing himself.
I recorded the
And
call.
in his best interest, he might want to listen to this call before he makes any further statements. Listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because he's interfered with it.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes,
Okay, could you please state your name?
thoroughly.
What is that noise?
Shouldn't you check? I don't feel safe.
What
Why are
is,
you just pointing? What? It'll stop at some point.
I feel very safe, Your Honor.
Oh, I know. He's like, you are all over it. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want it documented for potential additional charges. But this all happened, transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that that is what's being presented. I also want to indicate that.
Go
Go
ahead.
ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to your honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's your name?
Mary Rubio, Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Kwasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to have Mr. Lee before he makes more statements.
And I did record the. I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea. Not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Consley agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
He might want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right.
Okay.
I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay?
Okay.
All right.
Thank you, Your Honor.
Thank you. Somebody needs to listen to them.
Just listen to it.
Have you heard them? Or,
Just now, Oscar and I listened to it together.
okay, all right, I'll recall that momentarily.
And then everyone else is folded.
Everybody else is holding. And
Mr. Kennedy. Go down. That's-
four,
Yeah.
okay.
Yep.
So this one we're going last. Right, no,
No. This one.
that's
This
fine,
last.
so just hold down.
Yep.
Then it's between these two. What happened to ours?
That was at 2:00. We haven't gotten there yet.
Oh,
I haven't talked to you about those at all yet.
ow, okay. All right, but this one has one. And then we gotta bring Lee back out. So who's on this one?
This is for witnesses with Miss Tanha and I believe Miss Ackerley.
So then this is good night.
9 is Burkett.
How many witnesses on that? One witness? Okay. Get Mr. Burkett in here. We'll handle that one. I'm gonna take a brief break. We'll handle that one, then I'll get Mr. Lee out. Or, okay,
Thank you, Your Honor.
and deal with Lee.
That's my order then.
All right, Court of Sessions, Larry Lee.
All right.
Good afternoon, Your Honor. Marie Tin, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom. Oh, there you
Good
go.
afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was, the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Rubble sent me, as well as Mr. Burgess, and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No, Your Honor.
Attorney.
It's with Mr. Rubble, who's the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Rubble has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me until, and then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time. I was quick enough to get on my computer and record it, so that the court is aware of what's going on in the matter where I represent Mr. Quasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
Because it would have been unethical for Mr. Burgess to try to say, my client won't testify in this other matter.
Of course.
If that, right? That's
Well,
what Mr. Burgess may not have done.
and that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that, but I just wanted
Your Honor,
to make
if I
a
may.
record. What, could I just finish though?
Let her finish.
Mr. Lee
Sure.
indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. It's the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with the.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo is making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying. One of them being Mr. Lee, the other one being Mr. Quasi, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quasi not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. It has gone to law enforcement now, and we can follow up.
Mr. Arabo.
Your Honor, as you know, I'm a defense attorney. I think Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what is being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how this slipped between the cracks, because in over 10 years of practicing, I've never seen something like this, where a victim turns into a defendant during a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Kwasny so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Kwasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Kwasny using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this, and it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listened to it already.
Can somebody send it to Ms. Weidling, and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and sort of listen to the call. I can give my decision.
You have to go back.
To you. I'll handle that coming back out. I think Miss Atkins on that. So bring me that. Court's going to stand in recess. Everybody can remain seated. Bring. And I got this here. Now I got Kennedy Brown. And got it.
Yeah.
Okay. Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tanhouse, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Get your name, please. Okay. The issue is in this case that, first of all, we're adjourning the hearing over.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the.
Oh.
I'm on the bench, but I'm not doing these.
Okay.
So. Set his preliminary examination July to defendant's request. So my next date is July 22nd, 2025, and that's another 12 p.m. start because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think there, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not. because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr.
No,
Lee has
and
told
I
me.
understand that.
And Mr. Lee
I
is
think
about
when
jumping
you-
out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr. You might as well stop right now.
I have the text.
Because no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know what how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Take you.
Thank you, Your Honor.
Thank you, sir. Appreciate your wait and patience online.
What we just watched was more than courtroom drama. It was a perfect example of how quickly things can go wrong when defendants either misunderstand the legal system or think they can outsmart it. In the first case, the defendant clearly struggled to understand the difference between no bond hearing and actually being released, showing how confusing court procedure can become without proper legal guidance. But the second case was on an entirely different level. Once the judge heard that recorded conversation, the tone of the entire courtroom changed instantly. The court viewed the defendant's actions as a direct attempt to interfere with testimony and potentially manipulate the outcome of the case. And once a judge believes someone is violating bond conditions or tampering with witnesses, the consequences become immediate and severe. Bond revoked. Phone privileges restricted. Credibility destroyed in real time. What makes this situation even more intense is how the defendant kept trying to explain himself, while the judge repeatedly warned him that every additional statement could make things worse. It's a reminder that in court, words matter, strategy matters, and one bad decision can completely shift the direction of a case. If you found this courtroom breakdown shocking, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom moments and real legal breakdowns.